Good morning, everybody. Thanks for being here to talk about the Georgia Purchase and Sale Agreement. There are a few new things that we'll be going over today, so I'm glad you're here. Hi, Shonda. And if you guys want to just, put your comments and questions in the chat, I'll probably go over them at the very end. And just as a reminder, I will send you the slideshow afterwards. So if you guys wanted any of the notes, you can just listen today and you don't have to take separate notes. All right. All right, so just some important terms to know. We have the binding agreement date, which is the day when everybody involved in the real estate deal officially commits to the contract. We have earnest money, which is a deposit made by the buyer to demonstrate their serious intent to purchase the property. We have the closing costs, which are the expenses incurred by both the buyer and the seller during the closing of the real estate transaction, including fees for legal services, title, insurance, and taxes. We have a contingency, which is a condition that must be met for the contract to be binding. We have the addendum, which are additional terms or conditions added to the contract after the initial agreement. We have escrow, in which funds will be held by a third party, often the closing attorney, until all conditions of the contract are met. We have due diligence. Due diligence allows a buyer to fully understand what they are buying, time in which they can get inspections done, and possibly renegotiate or terminate the contract. And of course, a CMA. So CMA helps sellers and buyers really determine a competitive listing price or a competitive offer price for the contract. All right. So where can you guys find information on the new NAR changes? We're going to talk about some of them here today. But I just wanted you guys to be aware that there is a PDF. This is the link. It's a link that was put out by the Georgia MLS, and you can click on the link, download the PDF. It talks about all of the changes, what they mean, and which forms are new and which forms have been updated. So where can you find the new documents in dotloop? So under templates, there is a template category called GAR Interactive Documents. And in there, all you have to do is type in compensation, like I typed in to the search bar right here. And what's going to pop up is the broker compensation agreement and the pre-showing agreement, which are the new documents. So the buyer broker agreement is already preloaded into the Georgia residential purchase loop template. So when you go to create your loop in dotloop and you're representing a buyer, the buyer broker agreement is already going to be there for you. So I just wanted you to be aware of that. You will have to add the broker compensation agreement and the pre-showing agreement if you wanted to use those for anything. All right, so the pre-showing agreement is a new form. So we're going to talk a little bit about that. So buyer brokers who are being offered compensation by the seller or seller's brokers will have to find new ways to protect such offers of compensation. The GAR Forms Committee has developed forms that allow this to be done in a variety of ways. There's the co-op commission agreement, which is now the pre-showing compensation agreement. So another note is that we're no longer using the word commission, it's compensation. So this can be used by a buyer's broker to get the seller or the seller's broker, whoever's paying the compensation, to agree in writing to pay a specified amount of compensation to the buyer's broker. The seller or seller's broker can sign multiple copies of the form in advance, stating the compensation that's being offered and have it available to any realtor viewing the property. To protect the buyer's broker, whoever is paying the compensation, be it the seller or the seller's broker, should sign the form. In other words, the seller's broker does not want to represent what the seller has agreed to pay as compensation, since if the seller then refuses to pay, the seller's broker may have liability for what was promised. So this is the the pre-showing agreement. So at the very top, you are going to put the address of the property. And then in section 1, you're going to put what kind of compensation is being offered. So it's either going to be a percent of the purchase price, a flat fee dollar amount, or other, and you'll state those terms right here on line 3. In B, 1B, that's where you're gonna say who's paying the compensation. It's either the seller's broker, or it's the seller and the seller's broker. So either one of these 3 options. Then we have the general terms and special stipulations, which you'll probably leave blank. If you do have questions about this, please reach out to Kevin about verbiage. And then everybody is going to sign. So that is the pre-showing agreement. We also have the broker compensation agreement. There are some new changes. So the broker compensation agreement is a new form that's intended to be attached as an exhibit to the GAR purchase and sale agreement. It should be used in lieu of the buyer's broker writing a special stipulation into the purchase and sale agreement regarding the seller or the seller's broker paying compensation to the buyer's broker. The challenge in making compensation part of the purchase and sale agreement is that the brokers are not parties to the agreement. As such, they may have little ability to prevent the buyer and seller from amending the purchase and sale agreement and therefore reducing a broker's compensation from what was previously agreed upon. To mitigate this risk, the GAR committee has added language to try and protect the buyer broker's compensation once a compensation agreement is signed. Specifically, a provision was added stating that once this agreement is signed, it cannot be further modified without the express written consent of the brokers whose compensation is set forth, and any such modification shall be null and void without the affected broker's written consent. All right, let's take a look at it. So this is the broker compensation agreement. And at the very top, you're going to put the parties, you're going to put the date, and then in the first section, you're going to put who the compensation will be paid by. It's either going to be a percent, a flat fee, or some other arrangement. We have our general terms, our stipulations, and then everybody is going to sign. There really wasn't a lot of changes to the purchase and sale agreement. There was just kind of one big section that they changed, and this kind of goes over it. So the major changes to the purchase and sale agreement were made to the section on compensation of broker, which was previously called the brokerage section. The revised section explains that if the parties desire to state the compensation of any brokers in the purchase and sale agreement, or to modify previously agreed upon compensation, then a broker compensation agreement should be attached as an exhibit to the purchase and sale agreement. This section also states that if any provisions in the agreement changes the total compensation due to any broker, then such change shall only be binding if the affected broker consents to the change in writing. This change was made to try and prevent buyers and sellers from altering the compensation to be paid to a broker in an amendment to the contract. The section also includes language that licensees of brokers have the legal authority to bind their broker in agreeing, for example, on a change to their compensation. A broad definition of compensation was added to the purchase and sale agreement to reflect that it can be a commission, a flat fee, a bonus, or some combination of those items. All right, now we're going to get into the purchase and sale agreement. So section 1, we have the property identification. You'll list the full address of the property, the MLS number, if there is one, the tax parcel ID number, which can be found under the tax information in MLS or on the county assessor's. Then we have the legal description. So you'll select one of the boxes. If selecting number 4, all of the blanks have to be filled in. We have the purchase price, and this does not have to be what the property is listed for. You're going to rely on your CMA. We have the closing costs, which is what you would like the seller to contribute at closing, and this can be negotiated. We have the closing date and possession. You're going to put in an exact date here, and it can always be changed with an amendment later if needed. Will they have possession at closing or after? So you're going to list specific date and time if after closing. The closing law firm and attorney's information will go in number 5. We have the earnest money. So the holder is typically the closing attorney. You'll typically attach an exhibit to the contract, select one of the boxes, and fill in the earnest money deposit amount. We have the inspection and due diligence period, which is 10 days typically. The lead-based paint. So if the property was built before 1978, you will need to attach the lead-based paint exhibit and have both parties sign. The info on the lead-based paint can be found in dotloop, the info packet. Then we cover the brokerage relationships. So you're going to fill in the buyer and seller's brokers here, select how they're being represented, and make sure to explain in section C if there is a material relationship. We have time limit on the offer, so please list when your offer expires and be specific. Have the buyers and sellers initial at the bottom. All right, so we have the warranty. So the seller promises that when they sell the property at closing, they will give the buyer clear ownership rights. This means the buyer will own the property without any major legal problems, except for specific things mentioned in the agreement. For example, if the property is in a residential zone, the seller guarantees that it can only be used for residential purposes according to local rules. The seller ensures there are no major issues with utilities that could affect the property negatively. Any rules or restrictions already recorded in official documents, like condominium rules or community regulations, are disclosed and won't cause problems for the buyer. If there are any leases or other legal agreements connected to the property, the buyer agrees to take over those responsibilities from the seller. Then we have examination of title. The buyer has the right to check the property's legal status and get a survey done if needed. If they find any serious problems with the title that the seller can't fix before the closing, the buyer can back out of the deal without penalties. Then we have title insurance, letter C. The buyer instructs any lender involved in the deal to calculate the cost of title insurance. The insurance protects the buyer and lender from financial loss if there are hidden legal issues with the property's title that weren't discovered during examination. Then we have section 2, which is the purchase price to be paid by seller. So the buyer agrees to pay the purchase price in US dollars using a method accepted by the closing attorney, such as a wire transfer. And the seller will make a monetary contribution at closing, which the buyer can use to cover expenses related to the transaction. The seller will also pay for certain costs like preparing and recording title documents. And the buyer is responsible for paying specific costs at closing, including the property transfer tax, title search, etc. Prorations. So these are certain expenses like property taxes and utility bills that will be divided or prorated between the buyer and the seller based on the closing date. So either party can extend the closing date by 8 days under specific circumstances like title issues or lender delays. And then keys and openers and devices and fixtures. So the seller provides all keys, access cards, and codes necessary for accessing the property. And if specific systems or devices in the property require controllers or credentials, the seller has to provide these to the buyer at or before possession. So, closing law firm. The buyer has the right to choose the closing attorney for the transaction. If the buyer's lender doesn't approve of the chosen attorney, the buyer will need to pick another attorney that the lender accepts. The earnest money deposit will be paid to the holder, which is usually an escrow company or an attorney, and the holder may charge the buyer for any costs related to handling the earnest money. So entitlement to the earnest money deposit. The buyer gets the earnest money back in certain situations, like if the deal falls through or due to specific termination rights in the agreement. Otherwise, the earnest money will go towards the property purchase. The holder releases the earnest money based on the agreement terms, like after the closing or if there's a court order. Any party involved can object to the release of earnest money within a set time frame. Right, we have section 8, which is the inspection and due diligence. So the property is sold as is. The buyer has the right to thoroughly inspect it before buying. If there are concerns about illegal activities like drug production or environmental issues, the buyer can check government databases for relevant information. Buyers are responsible for checking neighborhood conditions that could affect the property, like noise levels or nearby facilities. They can review public records and databases for all of that info. The continuing inspection rights. So the buyers can continue inspecting the property until closing by giving notice to the seller, and they can conduct various inspections and tests. The seller must ensure access to all areas of the property. The buyers agree to hold the seller and broker harmless for any damages during inspection. If the property was built before 1978, the buyers have the right to test for lead-based paint within a specific time frame. If lead hazards are found, they will waive the right to terminate in a separate exhibit. The due diligence period. If there's a due diligence period, the buyer has the option to terminate the agreement for any reason during this period. They can also negotiate amendments to the agreement based on their concerns. The sellers must disclose any hidden defects in the property that the buyer couldn't find during a normal inspection. And the seller agrees to transfer any existing warranties or guarantees to the buyer at closing. And any agreed upon repairs or replacements should be completed as per the agreement. Number 9 covers lead-based paint. So if any part of the property was built before 1978, a lead-based paint exhibit is attached to this agreement. Section 10 covers the brokerage relationships. We have agency disclosure. Brokers in the transaction are bound by their brokerage agreements and the law. If a broker doesn't represent a party as a client, they can only perform certain tasks. Reviews all relationships over here and what they mean. So we have compensation to brokers. So this is the new section. There's just some new verbiage here. It is very similar to the previous contract. I think they just sort of switched some things around and elaborated a little bit. So this section outlines how real estate commissions are handled. Commissions owed to the seller's broker and buyer's broker are based on separate brokerage agreements. The closing attorney is authorized to pay the brokers their commission at closing. And if the sale proceeds are not enough to cover the full commission, the party responsible for the commission shortfall must pay it at closing. Accepting a partial commission at closing doesn't waive the remainder unless the brokers explicitly agree in writing. The brokers are signing this agreement to confirm that their role and consent to act as the holder of certain responsibilities. They are considered third-party beneficiaries to this agreement. C is the disclaimer, and this disclaimer emphasizes that the buyer and seller should not rely on the brokers for advice or representations beyond what is explicitly stated in this agreement. The brokers are not responsible for verifying the legitimacy of identities, inspecting the property for various issues, or advising on legal or financial matters. Number 11, we have the time limit offer. The time limit of the offer is crucial in real estate transactions. It specifies the deadline by which an offer must be accepted. If the offer is not accepted and notice of acceptance is not delivered before this deadline, the offer will be invalid. We have the section on notices. Notices must be in writing, legible, and signed by the party issuing the notice. Notices can be delivered in person, through courier services, overnight delivery, certified or registered mail or email. And a notice is considered delivered when the receiving party physically receives the written notice. Brokers and their affiliated licensees, when representing a party in a client relationship, are authorized to receive notices on behalf of that party. All right. Section 2 covers default. So if the buyer doesn't fulfill their obligations and the sale falls through, the seller can keep the earnest money as compensation. If they cannot force the buyer to go through with the purchase. So that would be the seller's remedies. Now, here are the buyer's remedies. So if the seller doesn't fulfill their obligations, the buyer can either insist that the seller follows through with the sale or terminate the agreement and get their earnest money back. Then we have the broker's rights. If either party defaults, the broker can receive a commission as if the deal had gone through, considering the agreed upon commission rates in the contract. In case of any legal dispute, like a breach of contract or commission claim, the party that loses the case may have to pay the attorney's fees of the winning party. Number 3, we have risk of damage. The seller promises that at the time of closing, the property and everything that comes with it, unless otherwise agreed upon, will be in almost the same condition as when the buyer made the offer. The seller should ensure that when the buyer takes possession, the property is clean, without any trash, debris, or personal items left behind. And if the property gets damaged or destroyed before closing, the seller must inform the buyer immediately. Both parties will have the right to terminate the agreement within 14 days of receiving notice of damage. If both parties decide not to terminate the agreement based on the damage, the seller must restore the property to its original condition before the offer date. And the closing date can be extended for up to 1 year if needed for the restoration and obtaining a new certificate of occupancy. Other provisions. We have condemnation. If the property is condemned, the seller must inform the buyer immediately. The buyer then has 7 days to decide if they want to cancel the agreement or proceed. Consent to share information. Both buyer and seller agreed to allow the closing attorney to share the settlement statements with relevant parties involved in the transaction. Duty to cooperate. All parties agreed to cooperate and fulfill their obligations under this agreement, including providing necessary documents or certifications. Electronic signatures are considered valid. There's that notice there. And then we have E, the entire agreement, modification, and assignment. This agreement is comprehensive and supersedes any previous agreement. Deadlines in the agreement are not automatically extended if they fall on weekends or holidays, except for the closing date. And if the seller is not a foreign person for tax purposes, they must provide an affidavit confirming this at closing. The agreement acknowledges the use of standard GAR forms in the real estate transaction and advises parties to seek legal advice if they have questions or need modifications. Governing law and interpretation. This agreement follows Georgia law, and if any part of the agreement is not legally enforceable, that part will be removed, but the rest of the agreement will remain valid. Brokers or their affiliated licensees cannot make binding decisions for the parties unless explicitly authorized in the agreement. They can help with administrative tasks like filling in dates, but cannot make substantive decisions without the parties' consent. The binding agreement date is when one party officially accepts an offer or a counteroffer and notifies the other party. And then objection. So if one party disagrees with the binding agreement date, they must raise their objection within 1 day of receiving notice. The objection is resolved through written agreement. If there are conflicts or inconsistencies in the agreement, handwritten changes override printed or typed parts. For FHA and VA exhibits, certain clauses in them will take precedence over conflicting clauses elsewhere. And the statute of limitations. Any claims against the brokers or their affiliated licensees related to a breach of contract must be made within 2 years from when the claim arises. Survival of the agreement. Certain parts of the agreement will remain valid even after the closing. These include obligations to pay commissions, warranties of title, representations about the property, indemnification, etc. We have the wire fraud warning. So always double check that wiring instructions are sent by email. Look up the contact number, company or person, call them directly to confirm the instructions. And be wary of emails that are asking to wire money to another state. Fraudulent emails may ask you to wire money to a bank or an account in a different state than where the transaction is happening. And watch for small differences. So criminals might create email addresses that are very similar to the real ones, but have just a slight difference. Limit on broker's liability. So this section limits the liability of the brokers involved. The broker's liability is capped at the amount of real estate commission paid to them, excluding any commission paid to cooperating brokers. If no commission is paid to the broker, their liability is limited to $100. Now we have all of the exhibits and addendums. So if you need any of these for your particular sale, you'll need to check off the ones you need. And you will need to add them into your dot loop separately from the templates list. They're all listed there, so you can just go and add them as needed. And then the last page, we have the signature section. Everybody has to sign. And that is it for the purchase and contract agreement. I am going to stop sharing now, open things up for questions, and I will stop recording as well.